All right. Good afternoon, everyone. We have our jail Zoom calendar for this afternoon. Looks like we've got 8 folks on the calendar, and I think we've got 2 additional matters. Mr. Lemons will be joining us from Department of Corrections, and I guess Mr. Smith wasn't on the calendar, but we'll take care of him as well. So anyway, I've been told to do city jail last. If that changes, let me know. I don't know why we're doing them last, but that's fine. I thought I'd start at the top of the calendar, which is Mr. Lee. Let me get him on. And Rios, 5 North. Let's see if it works. It does. Excellent. And one last thing in case we need to take anything down. Good afternoon, Ms. Burnett. Are you able to hear us? All right, I saw your microphone turn on. I didn't hear you, but I saw your microphone turn on, so that says you can hear us. I'll let you know when we need to take stuff down. Well, let's start with Mr. Lee. Good afternoon, Mr. Lee. Can you hear me?
Sir.
Great. Mr. Lee, you have 3 cases on the calendar, 3 different indictments. Ms. Rios, you represent Mr. Lee. What are we doing today with his cases?
I already filed a waiver of arraignment on these cases, Judge, and I did a referral to behavioral health court, so we're just going to go forward to final plea.
Okay. Ms. Nix, are you handling these cases, or Ms. Willingham? It's a couple of ag stockings with a spouse.
Davis. Hi, Judge. So the second 2 are, as of right now, assigned to me. The first one is technically assigned to Miss Davis, but I've already been in communication with the victim on it because I had to contact her about the other 2. She is the listed victim in all 3 cases. I've asked Miss Davis to file a formal in-house transfer, but I will make sure Miss Davis and I will work together to make sure all discovery is turned over, and I think we should be able to get that handled by the next calendar.
Okay, sounds good. So, Mr. Lee, here's the plan. Ms. Rios, who you can see on the screen there, is your lawyer. 2 of your cases fall into a special category with a special prosecutor. That's Ms. Willingham on the screen there. Your 3rd case falls into a different category, which would have a different prosecutor, but I think the DA's office is going to try to put it all in one place, which will make it easier for Ms. Rios to negotiate on your behalf and figure out what's going on. I will sign a scheduling order that will require the state to get all the discovery to your lawyer so she can meet with you, understand what's in there, what's not. And it sounds like she already has a plan in mind, which is behavioral health treatment court. I don't know if that's going to be a fit, but it's certainly worth exploring. Some of these charges might be ones that make BHTC a little reluctant to say yes, but certainly worth, like I said, exploring. I will see you next, either because Ms. Rios has filed some motions that we need to handle, or because we get to what she mentioned, the final plea date, which is one of the last days to have a negotiated resolution to your case. Do you have any questions about what's going on?
No, sir. No, I don't. Just what will be my next court date?
So I don't have a specific day to give you. I can tell you what it would be about, but not when it would happen. It would be about either a motion that Ms. Rios filed. She may get the discovery. I'm making this up, but it may say in the police report, we pulled our guns on Mr. Lee and made him confess to the crime. Well, that's not a good confession. You can't do that. And so Ms. Rios would file a motion to suppress the confession, and we'd have a hearing about that. You'd be here for that. Assuming there's nothing like that in the discovery, then I will see you next. You'll have a court date next when you and Ms. Rios maybe have worked something out with the prosecution and you want to enter a plea. Of course, you're not required to plea. Another date that will get you in here would be your trial date. That's a little ways down the road. We need to give the state some time to get discovery to your lawyer some time to look over the discovery herself, and then get with you. And then you all would let me know, hey, this is going to be a trial, or we want to work it out. So I suspect I won't see you for a few weeks, but that doesn't mean you won't see Ms. Rios. Once she gets discovery, she's going to want to meet with you, or someone on her team may want to meet with you to talk about options, okay?
Yes, sir.
All right. Ms. Willingham and Ms. Davis, I think the victim is on the call. I'm assuming she's good to go and doesn't need to be heard.
Yes, Judge, I was just going to let the court know that Ms. Lee is here. I will follow up with her once we conclude today.
That sounds like a plan. Ms. Lee, I appreciate you being here. You will always get notice from the district attorney's office when anything is happening with at least two of the cases. You may be the named victim in the third. I know you're the named victim in two of the three cases. And so you'll get updates as to when court's going to happen next. Ms. Davis, anything from you?
No, Judge, just wanted to give an update about the internal transfer. I did file that request last Wednesday. So,
all right. Well, we'll get that scheduling order out and that will get things moving along. Thank you, everyone. Mr. Lee, you are free to leave the booth if you want to.
All right, thank you.
You're welcome. That is a different hairstyle for Ms. Willingham. All right. Let's get to the next. 7 North Booth 1. So Mr. Lowe was supposed to be in 7 North Booth 1. Do we have anyone from the sheriff's team on who can give me an update about Billy Lowe?
Yes, sir. Give me, the floor has a situation. If you give me 2 seconds, I can have someone place him in the booth.
Great. We'll bounce to another one, and then we'll come back and see if he's there. Thank you.
Yes, sir.
Let's go here. All right. We have Mr. Gay next. I don't know who from the public defender's office is representing Mr. Gay.
He's mine, Judge.
Good afternoon, Ms. Wood. How are you?
I'm well. How are you?
I'm doing great. So I did a little research on Mr. Gay and noticed that we have 2 open cases. I was a little confused because when I looked at the petition, it's really a Judge Goger case. It's that old, but that means it's a Judge Richardson case, the probation matter. But it's here, appropriately so, because the primary alleged violation of probation is one of the 2 newer cases. And so all under one roof. But then I didn't think we'd probably just handle the revocation. We'd want to handle everything together. But that's not my call. So Mr. Gay, I just want to let you know you're on the calendar for a probation revocation. You have a pretty old case from back in 2015 where you entered a plea in front of Judge Goger and got 1 million years probation. And so that probation is still going. And while you were on probation, you picked up new charges. That's the basis for the revocation. But the new charges have been assigned to me. So that's why your Judge Goger case is presently with me. Ms. Wood, what's the plan for today?
Yes, Judge. So Mr. Gay and I spoke last week. And then, of course, yesterday, Ms. Davis and I did some further negotiating. So I have a new offer to convey for him for the new cases and the revocation. I'm happy to try to do it today, or I was going to ask the court if it would be possible to bring him over tomorrow. If it's not, I'm happy to do it. Like I can do a phone call with Cobb, but I know sometimes it gets tricky because I can't do a breakout session with Cobb.
Right. Well, let's find out from Ms. Nelson, because we were supposed to have like 18 case plea in the Hassan matter, but I don't know that GDC, the Georgia Justice Project, has really done what it needs to. And so I think we've got a chunk of time in the morning. It's just whether we have any slots to have people brought over. Ms. Nelson, would we be able to bring Mr. Gay over tomorrow for a plea in his 2 cases and the revocation?
Well, if I do cancel Mr. Hassan, yes, I can bring him.
Okay, tomorrow's not one of our inmate days?
It is, but I shared our inmate days because I had already prepared our calendar and someone else was needing additional days.
Got it. Thank you for sharing. That's a good thing to do. Ms. Davis, I don't want to incur the wrath of Mr. Amar. What's the latest you heard from them? Like if he shows up, like before there've been a bunch of people showing up for Mr. Hassan, how did you last leave things with him?
We are last in a holding pattern. He's still trying to get Mr. Hassan in one of the accountability courts, and there's still cases that need to be indicted. So there isn't really realistically anything that we could do tomorrow unless it's a partial resolution. But I know our goal is to globally resolve his 6 outstanding cases plus the probation cases.
Right. And no one wants a partial. So, Mr. Dunham is here tomorrow. Wow. Gosh, he represents a lot of positions on the calendar. I didn't realize, Ms. Nelson, we have a big old calendar with lots of stuff. It's not just Mr. Hassan. So we're really in a 1-for-1. We'd have to not transport Mr. Hassan and transport Mr. Gay instead.
Yes, Judge, that's my proposal.
Okay, let's do that. That way, Mr. Gay, Ms. Wood will have a chance to talk with you about the revised offer from the state. None of this is committing you to anything. You could get here tomorrow and say, forget it, I want a trial. And you, of course, have a right to a trial. But it may be that you're interested in resolving your 2 open cases, and then we'd roll the revocation into that as well. It sounds like it's a global resolution. Does that work for you?
Yes, sir.
Okay, then we'll get you produced tomorrow. You'll be brought over here to the courthouse. Ms. Wood will meet with you, and once the 2 of you have had enough time to talk about it, if it's a go, then we'll do the pleas. If it's not a go, I'll still see you, bring you out, and we'll let you know what's coming up next, okay?
Okay.
All right, Ms. Wood, does that work for you?
Yes, thank you so much, Judge.
All right, and Ms. Davis, are you the prosecutor on all this?
I am, Judge.
Okay, and you're good to go with that tomorrow as well?
Yes, I'm ready.
Okay, excellent. You had a question, Mr. Gay.
Same time or 9 a.m.?
Oh, it'll be in the morning. You will be you'll get awakened early since you're in Cobb and brought down here, and our calendar's at 9 in the morning. So it'll be in the morning.
And Mr.
All right,
Gay, I'll
thank you,
call
Judge.
your family after court and let them know, okay?
All right, thank you, Ms. Wood.
You're welcome.
All right, see you later.
All right, bye-bye. Thank you, Cobb.
You're quite welcome.
All right, so that's it for Cobb. Move the spotlight. Still don't have him, so let's move on to 6 Booth. Oh, we don't have Mario George in 6 North, Booth 1. So don't panic, Mr. Bernard. We will figure out where that person is, and we'll press on to 1-1 that we do have. Good afternoon. Are you Mr. Oop, you aren't on Just give me a second. Oh, right, you're the extra calendar. I knew we had you somewhere. Mr. Carter, all right. Good afternoon, Mr. Carter. How you doing?
All right, how you doing?
I'm okay. Ms. Wood, is this your case?
Judge, if you could just give me one moment, which calendar is this?
We have a add-on calendar with one position, Raymond Carter.
Right. So I had represented Mr. Carter way back when, and then like sort of at the end, he hired someone. If he wants me to work with him, I'm happy to do it. I would just need a breakout session.
Okay, and I don't mean to be taking a lawyer from you, Mr. Carter. Had you hired someone to help you with the revocation?
No, sir.
Okay, then what I'm going to do, well, let me just orient you to what's going on before we get on the record. And before we get on the record, I'll put you into a breakout room with Ms. Wood so the two of you can talk. But I signed a probation warrant in June of this year. It's alleged that you failed to report and you hadn't enrolled in MRT by a deadline that your probation officer had given you. So these are what we call technical violations. It's not new charges, but it's still something you need to work through. So I will let you and Ms. Wood talk. And when you guys pop back out, Ms. Wood may need to talk to Ms. Davis real briefly, but we'll figure something out. Okay?
All right, yes, sir.
Let me see if I can make this work. All right, you should be in there and I'll make sure you are unmuted. Yep, he's in there. All right.
Judge, I don't have the add-on calendar. Is there how many positions are on the add-on calendar?
That's it. It's just Mr. Carter.
Oh, okay.
So we're good there. Let me see who we've got. Are you handling Mr. Smith, Ms. Rios?
That's Miss Wood.
Okay, then what we're going to do is turn to Mr. Lemon. So we keep making, oh, wait a minute. We got someone, it looks like Ms. George. Is that you in 6 North Booth 1? Excellent. Is that, and that's Mr. Bernard, your client?
That is my client, Judge.
Excellent. Let me get everyone on the screen here and Mr. Bernard. Okay, and Ms. Davis, is Ms. George's case yours? It's number 10 on, yeah, it's yours. Okay.
Yeah, this is the co-defendant to Mr. Gay.
Yeah, there we go. Okay, and then I got to unmute things for Ms. George. Let's get in there. It's North. System's working well today. There we go. All right. Ms. George, can you hear me?
Yes, sir.
Excellent. So I'm Judge McBurney, and your case is on the calendar because you missed court. Mr. Bernard actually swung by this morning, figuring out when exactly we'd be meeting, and learned it was on Zoom. So he asked if he could appear virtually, like he is. But he represents you. Ms. Davis, who's also on the screen, is the prosecutor handling the case. And we need to talk about why you missed court and what is going to happen as a result of that. And I also want to see where we are otherwise with your case. So, Mr. Bernard, why don't you get started? But why don't we get on the record? So this is 25 SC 002 332. Ms. George is appearing virtually from the jail, Mr. Bernard virtually, and Ms. Davis for the state is virtual. And we're going to talk a little bit about the bench warrant and then whatever the procedural status is of the case.
Yes, Judge. Thank you. Ms. George reached out to me a few weeks ago, several weeks ago, as a matter of fact, letting me know kind of what the situation was. I in turn reached out to another prosecutor, not Ms. Davis, on the case because I wasn't sure who had the case. But all that being said, Judge, Ms. George, Ms. Court essentially because her residence is really in New York. And so she was in Georgia to kind of handle this case, to try to resolve this case. However, with the situation happening in New York, there was a situation that was happening in New York that required her to leave. In addition to that, she just didn't have a place to stay in Georgia, in Atlanta, to kind of see the case through. And so that's essentially why she missed court. What we'd be trying to do is to see if we could get her bond reinstated. It's my understanding that the case initially was referred to pretrial diversion. And so we would be trying eventually to try to get that offer again. But I know that it's a process and we have to work with the prosecutor's office, Ms. Davis in particular, it looks like, to see if we can't get that reinstated.
Okay. I think I followed all that. A little confusing about whether you were saying Ms. George had to get out of New York as well.
No, she didn't have to get out of New York. She's got a child that's in New York. And so she had to get back to her child. So she had to leave Georgia because one, she didn't have a place to stay in Georgia. Two, she had a child in New York that, of course, required her supervision.
Okay. So the address in the system for Ms. George is a Decatur address, an apartment in Decatur. Is that where you stayed for a little while, Ms. George?
No, that's my current address. At the time, I was having health complications, and I have a daughter, and she was graduating high school, and I was back and forth. I am a Georgia native, by the way, and I missed court because of that reason. I was having health complications, and I had my daughter to tend to at the time.
Okay. When you get out, whenever that might be, you're not going back to New York. You'd go to this apartment in Decatur?
Yes, sir.
And what makes you think that the apartment is still available to you?
Because I pay rent there.
Okay, well, you've been in custody now for 27 days. So have you missed a rent payment or?
No, sir. I have savings, so everything is taken care of.
So if you're released, it would be to return to that address.
That is correct, sir. Yes, sir.
Who else stays in that apartment with you?
My father.
Okay. Does your father work?
Yes, he does work.
What does he do?
He's a carpenter.
And do you work?
Currently I do. Yes, sir.
What do you do?
I do hair.
Say that again?
I do hair. I'm a cosmetologist.
Got it. Okay. Do you have your own salon somewhere or a booth somewhere, or people call you up?
I'm sorry, me and my daughter, we have a business together. It's called Critique Styles. She's also a hairstylist as well. She just graduated high school, by the way.
Where did she go to high school?
She just graduated from a high school in the Bronx. It was called Bronx Regional High School, and she just got accepted into Bowie State University in Baltimore, Maryland.
That's fantastic. Congratulations to her. How did you guys run a salon if you were in Decatur and she was in the Bronx?
It's like we have a suite in New York and we have a suite in Atlanta. So like if I'm in Atlanta, I'll take clients. If she's in Atlanta, she'll take clients, and we just be back and forth basically.
Okay. All right. I think I follow all that. But then tell me where, if you've you're sort of a Georgia native and have had this address for a while. In fact, your dad stays there. Why would you not have made it to court in June? It's just 2 months ago, 3 months ago, we're talking about.
Several health complications, and at the time, my insurance was not being accepted by Georgia because it is from New York. So I had to go back to New York and get treatment and care for my health situation at the time.
Okay, so you were out of state at the time working through a medical situation.
Yes, sir. I do apologize for my perhaps missing court, but it won't happen again.
Okay, all right. Well, I appreciate you sharing all that. Mr. Bernard, last question for you, then I'll hear from Ms. Davis. Where did you get the sense that pretrial diversion was on the table? The docket has very little in it, not that that would be in the docket, but basically it was unindicted, then it was indicted. It went to a judge who said, wait, there's an older case with Mr. Gay, transferred it here. There hadn't really been much court activity. Had you been interacting with a prosecutor, or was this more your wish list?
Both. No, Judge, this was information conveyed to me through Ms. George. So I'm not sure if the pretrial diversion was in fact offered. But you know, our main goal was and Ms. George may be able to clear it up, but my main goal was to try to figure out whether or not we could get a bond. But she did convey to me that there was a pretrial offer on the table.
At the time, Your Honor, I had when I was initially arrested for the charge, I was booked, and the next day I was released into the pretrial intervention program, where I did attend 3 times, and I did drug tests, and then I had to go back to New York. So that's what prompted the warrant and me missing court and stuff.
Okay. Got it. Okay. Ms. Davis, what are your thoughts about what we do here?
Judge, I have some concerns with the ties to the community. I am a little bit confused about whether Miss George's residence is in New York or her ties to New York, but most importantly, her ties to the community here in Georgia. I'm not really sure she satisfied that requirement because it did go to the address that she's stating that she lived in. However, she did not appear on her court date in June. Also, I think maybe Miss George may be interpreting the pretrial release, her bond conditions as diversion. And based on the history that I'm seeing on the GCIC, she would not be an eligible candidate for the DA's office adult diversion program.
Okay.
Your Honor, I was released into the pretrial intervention program, and I did attend 3 times. I did receive my court notice, but I was in New York at the time receiving care and treatment.
Okay. No, I've heard you, Ms. George. I'm not doubting that part. Ms. Davis is helping me understand, I think, what's just a terminology difference we have here. But I did notice on the bond, it was pretrial services level 3. And so that might well feel like pretrial intervention. Okay. I've heard you on that, Ms. Davis. It doesn't sound like there's a victim where we need to stay away. It would obviously be stay away from Mr. Gay, but that would be it. And so your primary concern is just ensuring that Ms. George would come to court next time she needs to come to court.
Correct.
Okay, got it. Yes, ma'am.
Also has a warrant in Franklin County.
Oh, is it a probation warrant or it's just a hold?
It's a probation warrant.
Okay. Ms. George, Ms. Simpson, who is with probation, the Department of Community Supervision, shared with me that you actually have a hold out of Franklin County. I don't know where that is. It's in Georgia somewhere. And I guess you're on probation out of Franklin County. Does that sound possible? We're talking about the right person?
Yes, I've been on probation for the past 10 years, I want to say, for an old case.
Judge, we do know that there is a Franklin County hold.
Okay.
We're working through that as well.
Okay. What is the probation for, Ms. George, out of Franklin County?
for an old case that I've been a DOC already on it. It was for, monetary instrument abuse about 10 years ago.
Okay, tell me the charge again. That's what I was asking about.
It was monetary instrument abuse, I think, a check fraud.
Okay, got it. Got it. Okay. All right. So Mr. Bernard, if you could do a waiver, assuming Ms. George wants to waive arraignment, if you could do a waiver of arraignment, Ms. Nelson could send you one. I don't remember if we've got them on the website, if you go to the court website, but will you be representing Ms. George throughout, or are you here just for the bond situation?
No, Judge, I'll be representing her throughout.
Okay. So here's my thought. I see that Ms. George actually does have a fair amount of contacts with the community, in part by looking at her arrest record here in Fulton County. She's clearly been in Georgia a fair amount. I also see that this allegation is not particularly serious. It seems like a resolvable case. I'm a little leery of having Ms. George go off to Franklin County, and I'm not sure when we see her again, because what I'm inclined to do would be to modify her bond to add a county-funded ankle monitor, just so we address the concern I share with Ms. Davis. But that's kind of hard to do if she's going to Franklin and then she's released from Franklin. And so what I'd like to do, assuming you do that waiver of arraignment, is have Ms. Davis get you discovery and see if this is a case that we can resolve pretty quickly. I sense that the resolution would be one that would then get Ms. George off to Franklin soon so she can deal with that hold. It would also mean that this whole matter has been resolved, as opposed, I don't know what's pulling her back to Franklin, but if it's the arrest in this case, then it would actually be the resolution of this case that would be complete, so that when she goes to Franklin County, it's just for everything and not 2 trips down there.
Right.
So that said, I'm happy to revisit the question of bond if, when you get discovery, you learn that, you know what, Judge, there's going to be a trial. That won't be for a few months. Then we certainly need to get Ms. George off to Franklin County to deal with that. And I might just put a hold on her so she'd come back here to get the ankle monitor on.
Okay.
So I'm not trying to prolong the stay. I'm trying to actually streamline the process.
But ankle monitor today, Your Honor, like this is like really giving me a headache. I have health complications and they have me in a PC dormitory. I'm going through a lot back here. I'm a transgender person. I cannot, I really have to get out, please.
So Ms. George, I'm hearing you on that. In fact, I made a note to reach out to the sheriff because I was sort of surprised that you were on the 6th floor, and there's no notation in Odyssey to let folks know about the things you just mentioned. So I'll reach out to the sheriff's team to address that. But I'm going to have Mr. Bernard do the waiver of arraignment and get your discovery. And then he may say, Judge, you know what, please just send her down to Franklin County. And if that's his request, I can figure out a way to lift the hold here and then put one back in place so you can get down to Franklin County. But I want to be clear, whether I reinstate your bond or not, it's not like you're driving yourself down to Franklin County. It would be law enforcement transport from here to Franklin and then back to here to get the ankle monitor on. Okay?
It's only for probation, so
Judge, I'll be out to kind of explain and put more meat on the bones for Ms. George.
Okay. All right, and I'll repeat, I am open to, fine, let's lift the hold, let's get Ms. George down to Franklin. If you, Mr. Bernard, get the sense that it's going to take a while on the Fulton side to resolve this, but if there is an easy and prompt resolution, I am perfectly fine getting Ms. George over here. You can appear virtually, Mr. Bernard, to do that resolution. Pick the day. Adding one defendant on a given day, as long as we have a little bit of notice. Then we can make that happen. So, Ms. George, you're holding your head a lot. I don't want you to think that what we're talking about means I won't see you for 6 months. That's not what we're talking about at all. Okay?
Thank you, Judge.
Ms. Davis, anything else from the state?
No, Your Honor.
Okay. All right, Mr. Bernard, we'll wait to hear from you. If you'll get that waiver of arraignment into Ms. Nelson, that'll get the scheduling order out. That'll prompt Ms. Davis to get you the discovery. And then my guess is that's a pretty quick read, given what the charge is. And then you and Ms. Davis can see if this is a sort-outable case, and then we'll get Ms. George here whenever you say.
Absolutely, Judge. Thank you.
All right, thank you. Ms. George, you are free to leave the booth. And like I said, I'm going to let the sheriff's team know that you probably need to be in a different spot at the jail, okay?
Okay, not a PC dormitory, like a regular dorm, possibly, please. Thank you.
All right, you're welcome.
Judge McBurney.
Hello?
Hi, this is ACDC. How are you, sir?
I'm fine. I was told to do you guys last.
Okay, well, I was able to finish my other course, so we're on. Just letting you know that we're on.
Okay, you're ready to go.
Yes, sir.
Good. All right.
In front of you is position 7, Ms. Hayes, and then position 8.
Got it. Thank you. Ms. Wood, you made it back. Did you have enough time to speak with Mr. Carter?
Yes, Judge, and we're ready on that one as well.
Okay. All right. Well, let's turn to Ms. Hayes first. I think that would be yours, Ms. Rios.
Yes, Your Honor.
All right. Let's get you there. And there's Ms. Hayes. Okay. And okay. Well, let's get on the record. This is position 724 SC 004746, State versus Hayes. Ms. Hayes is at the city jail. Ms. Rios, her lawyer, is online, as is the prosecutor, Ms. Davis. Good afternoon, Ms. Hayes. I can't hear you. Can you speak up a little bit?
Afternoon, how are you?
Okay, I'm doing all right. That was better. So Ms. Hayes, I signed a probation warrant in June of this year that says that you were hard to find. The probation went to the address where they thought you'd be and they couldn't find you. And they were trying to figure out where are you working and where are you living. So sort of what we call absconding. Ms. Rios, is Ms. Hayes admitting to the allegation in the warrant and petition?
Yes, Your Honor.
Is there anything you want to add about what happened or what might be different going forward?
Yes. So I spoke with probation, and also we're in agreements of revoking the 3 months that she's been in. I provided probation with the new address. She'll be living with her brother in Dunwoody, and I provided his phone number. She was working at Wendy's, and she's been having a hard time with finding a job, but she's actively looking for it. And she also applied to food stamps. I believe had an interview at Willie's. So I'm asking for her to, for you to go with the agreement of just revoking the 3 months that she's already been in. I'm just going to check the date that she's been in, but I believe it's 3 months.
Okay, she's been in 52 days, so it's a little less than 3 months. Ms. Hayes, you said you'd be staying with your brother? Okay, that's not, hold on one second. That's not Antonio, is it?
No.
Okay.
I haven't had contact with him.
Can you lean into the microphone and say that again?
Okay, I'm sorry. He is incarcerated right now. I've learned that from my mother and my brother, so I haven't had any contact with him since.
Good. All right. Yeah, he's off limits to you. I didn't know he was in custody. We've been looking for him. Okay, so you'd be staying with a different brother in Dunwoody, and does he know that you will be getting out soon to stay there?
Yes, sir.
Okay. Do you understand that when you're on probation, it's important that you keep your probation officer current with whatever your address is? So if you need to move out of your brother's apartment to move somewhere else, that's okay, but you have to tell probation, I'm moving from Dunwoody to Smyrna. I'm moving from Smyrna to Conyers, wherever it is you're going, okay? Who were you living with in Decatur, Flat Shoals?
His name was Tyrone Cook, and I did call the probation because I'm supposed to report to the probation twice a month, and I did call them, and it's on a recorded line, so I have no idea whether they reported to that address, but I did update my address. So I have no.
You told them you were moving to that Dunwoody address?
No, I was at another address, but when I was arrested, my brother moved into another apartment. I was living with my sister, and I informed my brother, that I was gonna use the address. We had already made plans to move into there, so this address is new.
Okay. All right. Ms. Davis, anything from the state about Ms. Hayes?
No, Your Honor, I just want to make sure Ms. Hayes provides that correct address to probation, and they said they need a updated contact number as well.
I emailed that to Ms. Simpson
Okay.
before court, so we're all
Okay.
good.
Okay, so Ms. Simpson, the contact number would be for Ms. Hayes's brother, the
Yes, Judge.
person who's in the apartment?
Yes, Judge.
Ms. Hayes, is there anyone else in the apartment besides your brother?
No, sir, it's just me and my brother.
Okay, all right, and you're hoping to get a job at Willie's?
Yes, but I've been here for, like you said, 52 days, so I'm not sure if they held on to that for me because I did work for them for at least like 5 years since I was a teenager. So I'm not sure. I would have to contact them, but I got a little faith about that. I'm not, discouraged about it. I'll contact them.
Okay, well, as long as you're keeping probation posted that you're looking for a job, and once you get it, what that job is, that should work out. All right, well, Ms. Hayes, I am going to follow this joint recommendation and revoke 3 months of your probation. We'll reinstate the balance, and you'll be required to reside at that Dunwoody address. If you need to move, you need to alert probation before you move. So don't tell them, hey, now I live in Smyrna. It would be, I need to move from Dunwoody and I'm planning on moving here, so they know in advance, okay? It's your job to be findable for probation, and not that they have to work hard to track you down. Ms. Simpson, are there any reporting instructions for Ms. Hayes?
Yes, so Ms. Hayes.
Can you bend the microphone down towards you?
You need to report back to the Atlanta office within 48 hours of your release. Once you've reported there, they should have the new address in the system. So then they'll be able to transfer your case. I believe you'll be going to DeKalb County. But for the meantime, when you get out within the next 2 days of your release, you need to report to the Atlanta office, which is 276 Memorial Drive. It's the same office you were already reporting to.
Okay.
Your Honor, I think I misspoke or someone misspoke or I got confused. It's supposed to be 30 days, not 3 months. I think I sent 3 months. I'm sorry. 30 days is what the agreement was.
Yes, Judge, that's my understanding, was 30 days.
Okay, well then what I will do, 3 months is a whole bunch more days. So what I'll do is say we will revoke 1 month and reinstate the balance. So correction, not 3 months, but 1 month. You've already done more than a month, Ms. Hayes, so you ought to get out probably tomorrow. The paperwork needs to catch up to you, but you ought to be released sometime tomorrow, okay? All right, well, good luck with everything, and I hope I see you at Willie's and not at the city jail, okay?
Yes, sir.
Bye-bye.
Okay.
1 month. Oof. How do you pronounce your last name?
Guter.
Guter. All right. Let's get Ms. Wood on the screen here. And is this your case, Ms. Nix?
Yes, sir.
All right. I'm just looking at the case file here, Mr. Guter. This is some older stuff.
Not a bad guy, Your Honor. I actually go after criminals in my spare time. I don't know if that's appropriate to say at this time, but I do.
I remember you. Okay. So let's get this on the record. This is 22 SC 184420. State versus Guter. Mr. Guter is appearing from the city jail. He's represented by Ms. Wood. And Ms. Nix is here in court. Can you move the monitor a little bit so that Mr. Guter can see, or you can move you, whichever you'd like to move. Don't scowl. Well, he needs to be able to see you. All right. In reading the motion to set aside bench warrant that Ms. Primovic, who's a colleague of Ms. Wood, filed, it all came back. We had some kind of arraignment or something in this case, and you were on Zoom, and you didn't really want to talk about where you were, didn't come to court despite my direction, and then got off of Zoom. And I said, I'm going to let you talk in a minute, but you got to let your lawyer do most of the talking for you. But the way that played out, and frankly, the sketchiness of what was going on in the face of what these charges are, prompted me to say, well, let's get a bench warrant for Mr. Guter. That was literally years ago, and that bench warrant caught up with you, and here you are. So Ms. Wood, take it from there.
Thank you, Judge. So yes, this is an older case. He originally was in custody for 273 days between December 18th of 2019. He was released on September 15th of 2020. And of course, as you know, this case was indicted some years later. When it was indicted, the attorney he had originally worked with from our office was no longer here. There was a bit of miscommunication on that front. And so thankfully he landed on Ms. Primovic's desk. And so now we are plugged in with Mr. Guter. I think that was part of his issue with our office, is that he was trying to update stuff with his attorney, and of course that attorney left. As you know, that happens quite often. So he has been in custody this time for 46 days on the bench warrant. He was living in Dothan, Alabama, at a senior living apartment facility there, Judge. I actually finally spoke with them on Friday. If he is to be released, they still have his belongings there. He's just going to have to go back, like a reapplication process, it sounds like. He is originally from New York. He's 64 years old. Like I said, he's established in Dothan, Alabama right now. He's retired. He did computer IT type work. He has some health issues he wants the court to know about. Apparently, he had a heart attack while he was trying to get from Dothan to Atlanta. So yeah, I've already started working with Miss Nix. She has kindly sent over discovery very early on. So we're going to be diligently working on a resolution in this case. He just is asking the court to set aside the bench warrant and reinstate bond.
Okay. Yep, you've already done a waiver of arraignment, so that's good. We're moving along. Ms. Nix, strange set of procedural facts here. What are your thoughts about bond? I guess it took a long time for the state to do something with the case, and so bond went from 95,000 to 17,000 to the last bond I saw in there from a now senior judge was a signature bond, which I don't think is legal. But setting that aside, here we are several years later.
Yes, sir. It appeared to be a $14,000 signature bond. And I believe that it was such because of COVID, which is also, I believe, why it wasn't indicted until 2022. It looks like the first motion to recall the bench warrant was filed by Ms. Primovic in January 2023. I was not on the case at the time and did not know about the sketchiness of the defendant refusing to provide an address. But that motion did state that the defendant was homeless and living out of state, which raises red flags for me. And then with the defendant having to be extradited from another state, also shows a likelihood of failing to come to court. So we have a signature bond, so he didn't pay anything to get out of jail. One motion saying that he was homeless and then refusing to give an address. Now, another over 2 years later, he's still living out of state. And I just am not seeing anything, hearing anything that says he's going to come back to court for these very serious charges. So we would oppose recalling the bench warrant. If Your Honor were to recall the bench warrant, we would ask that he be required to make a bond in order to be let out of custody.
All right, Ms. Wood, anything you want to say in closing about Mr. Gooder's situation?
Yes, Judge, I completely understand the state's position. I would just add to the court that I'm plugged in, I'm in this courtroom, and so we've got good contact. So if the court does see fit to lift the bench warrant, I'm confident Mr. Gooder would stay in touch with me, as I have all the phone numbers and the email addresses and everything placed now, Judge.
Okay.
Absolutely, Your Honor. Absolutely.
Okay.
I've been living down there for 2 years, retirement community, no problems. Like I said, I've been trying to get back to work and actually go after, criminals, like scammer criminals, the phone calls, the text mails, the emails, the fake websites. I used to do tech work for almost half a century, and I've been trying to get back into the tech work, but my age is age discrimination. So I guess it. I found out from another, my cellmate, that there's a place called American Public University Systems. He got his doctorate there, or his master's. They have very inexpensive courses where I could get cybersecurity. So that's one of the reasons why I've been told why I can't get back into working and going after scammers, because I do not have any cybersecurity certifications, even though I do have a ton of other certifications, from other A+ and other manufacturers. So, I'm not a bad guy. I'm not a criminal. I've been stable down there for 2 years. Had a good rapport with, my apartment manager. No problems at all down there. I'll do whatever needs to be done. To do whatever needs to be done, I guess. I'm old. I got health problems. I'm not a bad guy, Your Honor.
Okay, I'm hearing you. What I'm going to do for now is maintain the status quo. I'm going to ask Ms. Nix to report back to me and Ms. Wood within a week, so by next Wednesday, about your ability to contact the alleged victim. If you are able to do that, then we're going to keep Mr. Gooder where he is until we resolve the case, unless there is some delay occasioned by the state. Can't find the forensic interviewer or whatever it might be because of the age of the case. But if this case can move promptly, which it ought to, given the fact that someone's sitting in custody, then I am comfortable leaving the hold in place. Several years passed with Mr. Gutter not making any effort to contact the Fulton County Public Defender's Office, which is not a hard office to find. While he allegedly had a stable residence and was doing well, and apartment manager likes him, et cetera. That to me isn't consistent with someone who's going to make it easy to get him back to Georgia to face these serious allegations. But they are only allegations. So I want to be comfortable that the state's going to be able to find the alleged victim if this is something that's going to go to trial.
Yes, sir.
So
Started the processes.
great. So please report back within a week. And in the meantime, it sounds like you've already got discovery flowing. So Ms. Wood, if there are motions we need to hear, let me know. Otherwise, I can ask Ms. Nelson to have this one move quickly, unless you need it not to. You can always say, hey, we're going to need an expert to do X, whatever it may be.
Understood, Judge. Thank you.
All right. Thank you, everyone. And thank you, City Jail, for getting these two defendants available.
Is there anything else I can say on my behalf, Your Honor? Or?
No, right now, probably less is more. All right. Thank you.
Lacey, the GBI reports in this case I added today, and I hit the little thing that says share with the Public Defender's Office, but I never know if those actually get to you. Did they get to you?
I will double check. I didn't get an alert, but I'll double check. Thank you.
Okay, I'll reshare them if I don't hear from you.
Okay, thank you.
All right. So let me recap. Did we ever find Billy Lowe? That was booth 7.
That's my only case, Judge. May I be excused?
Yes, ma'am. There he is. 5 through 9. Ms. Rios, is Mr. Lowe your case?
Yes, Your Honor.
All right, let me get you right there. Bye to Ms. Nix. And Ms. Davis, I got to unmute 7 North Booth 1. Good afternoon, Mr. Lowe. Can you hear us?
Yes, you will.
Great. Mr. Lowe, we're here to handle your arraignment in your case. Ms. Rios represents you. She's on the screen there. And then the prosecutor handling your case is also on the screen. Ms. Rios, I haven't looked in the docket yet. You may have already filed a waiver. What are we doing with Mr. Lowe today?
I filed a waiver. We're just going forward to getting a scheduled order.
Okay. What is keeping Mr. Lowe in? Is it too high a bond in this case? Is it the state court case he has? I'm just looking at the charges he has here. And I'm curious.
Let me double check.
While she's looking, Mr. Lowe, so you know what's next, because Ms. Rios has waived arraignment on your part, I'll get a scheduling order in. That'll obligate the state, Ms. Davis on the screen there, to get all the discovery in your case. So police reports, body cam, whatever it may be. She'll get that to your lawyer so you and your lawyer can look at the case and figure out what you're going to do. Okay?
Yes, you will.
All right.
Your Honor, it looks like there is two different cases. I'm trying to see if this PI, I might have made a mistake because I thought it wasn't this case holding him in either, but let me make sure the charges look, let me make sure that this is not, I think it's the PI case what's holding him in, but let me just double check.
Yeah, looks like a different case.
Yeah.
But it says transferred to state court, so that's probably become that CR matter.
So the PI case was transferred down to state court?
I think so. Let's look. No, that's a different, so it could be either of those. Yeah, I don't know. But it sounds like Mr. Lowe has multiple pieces of business to deal with, so.
It actually, it does look like when I type in the number, it says transfer to state court. Pre-indictment transfer to state court, so I think that is one case that was just transferred to state court.
Okay. Well, the charges in that CR number on the calendar seem to be a little bit different. But either way, we've got the obstruction cases. You're representing Mr. Lowe for that. You'll get discovery and we'll see where that takes us. Mr. Lowe, any questions?
No, you are.
Okay, well, we'll see you soon. Thank you. You're good to go. All right, so what we have left, I don't have that listed on here. Marquita Brown?
That's position 9.
Yeah, but I don't have that listed anywhere. Like, I don't know where that person is.
She's in Clayton County, we believe.
Oh, so not brought over today.
Yeah, in the system it said transferred to out of state or out of county, and it looks like it's Clayton County. So I think we have to reset.
Okay, reset. All right. So I think what I'd like to do now is take Mr. Lemons's plea, and then we can do Carter and I think Mr. Smith was on for a plea.
Judge,
Yes, ma'am.
is it possible while you're doing Lemons, if I can do a breakout session with Mr. Smith?
Sure.
Thank you.
You bet. Let me get everyone in place here. So Smith, 4 North, booth 1.
Yeah, I think that's all I have. May I be excused?
Yes, ma'am. Thanks for being here. See you around. Hey, Mr. Smith, can you hear me?
Sir, how are you doing, Your Honor?
I'm doing all right. I am going to put you in a breakout room with Ms. Wood so she and you can chat a little bit. When you pop back out, we may be getting ready for your plea. I got to take another plea first, but then we'll get to your case, all right?
All right, sounds good.
Okay, I think we've got everyone we need for Mr. Lemons's plea. Mr. Lemons, you able to hear us?
Yes, can you hear me?
Yes, we can hear you. Mr. Glenn, are you good to go?
Yes, I am, Your Honor.
Okay.
Revocation.
Then let's see if we can make this happen. We'll get on the record. This is 25 SC 001607, State versus Lemons. And we've got Mr. Glenn representing Mr. Lemons, Ms. Davis representing the state. Mr. Lemons is appearing from the Department of Corrections. Thank you, GDC, for making him available. Mr. Lemons, I need to ask you two questions before I let Ms. Davis take over. The first is, are you waiving your right to appear here in open court and agreeing to proceed virtually?
Yes, sir.
And the second is, are you waiving your right to have Mr. Glenn by your side and agreeing to let him appear virtually?
Yes, sir.
If you need to speak with him privately, let me know, and I'll put the two of you in a breakout room so you can have a confidential conversation, okay?
Yes, sir.
All right, Ms. Davis.
Mr. Lemons, please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court will be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Tyson Lemons.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
Ma'am.
How old are you and how far have you gone in school?
I'm 5 to 6 years old. I made it to the 10th.
What high school did you attend?
Fulton High.
Where's Fulton High?
It's all over there on Jonesboro Road.
Okay.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment 25 SC 001607, burglary in the second degree? There are 3 counts.
Yes, ma'am.
Do you understand that you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Glenn, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Attorney Glenn, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes, I do.
Mr. Lemons, thank you. Mr. Lemons, do you remember having been arrested on these charges?
Have I ever been arrested on the charges?
Do you remember having been arrested on these charges?
Yes, I remember.
Okay, that's all it's asking. I want to make sure you remember you were arrested for these things at some point. It would have been a long time ago in July of 23 or something like that, but you remember that?
I don't remember getting arrested for the charge until a couple months ago.
Okay.
Yeah, he was a judge. He was arrested in October of 2024. Do you know you were arrested last year?
Yes, ma'am.
Okay. Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Glenn, are you aware of any outstanding warrants related to this case?
No, I'm not.
Mr. Lemons, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
For burglary in the second degree is a minimum of 1 year and a max of 5 years. Do you understand today, Mr. Lemons, that you are entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court's not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you are pleading to today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you would be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over about 9. Afterwards, I'm going to ask, do you understand, okay?
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 25 SC 001607, burglary in the second degree?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty? I'm sorry?
Say what now?
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Judge, at this time, the state believes if this case were to go to trial, that the evidence would show between July 3rd and July 5th of 2023, the defendants, including Mr. Tyson Lemons, along with the co-defendants, entered the property of CSX Railroad located at 173 Boulevard Street in Atlanta, Georgia, in Fulton County, with the intent to commit a theft thereon. Officers with the CSX Railroad Police Department discovered that 7 shipping containers had their locks removed and tires stolen out of them. Also, CSX captured some surveillance footage from a nearby location, the pencil factory, which was the staging area for these vehicles to transport the property that was removed from the shipping containers and transported away from the property. There were many tires that were in a truck bed, a white truck that was related to the defendant, Mr. Lemons. Officers did recover 2 cell phones, one belonging to Mr. Lemons and Mr. Lemons' significant other, waiting in a vehicle that had been used to transport some of the stolen goods, including several microwave units. And it's because of that vehicle that officers were able to tie Mr. Lemons to the scene. They also captured several images which they attribute to being Mr. Lemons. At this time, we are mirroring our sentence for Mr. Lemons in line with the other co-defendants, with the addition of jail time because Mr. Lemons has already been sentenced to 2 years. So the sentence would be 5 years to serve 2 years in custody, the balance on probation. We're going to reserve the right for restitution. The restitution is a little bit more complicated, but we do want to reserve the right to have an opportunity to have a hearing on that. We would ask that Mr. Lemons complete an anti-theft course, complete 60 hours community service, no contact with his co-defendants, and to stay away from all railroad properties. The co-defendants being Mr. Willie Jones, Mr. Jairus Talbot, and Mr. Cartisius Wise. And nothing further from the state.
All right, thank you. Ms. Jackson, good afternoon. Do you have any criminal history information on Mr. Lemons?
Good afternoon, Your Honor. There are 49 cycles. The last arrest was April the 8th, 2025, out of Henry County for driving while license suspended or revoked. There was no disposition for that arrest. He does appear to be on probation in Douglas County for cargo theft. That disposition date was February the 28th, 2024, and the term is for 10 years. He does have prior felony convictions, one in 2018 for possession of marijuana with the intent to distribute, one in 2007 for possession of cocaine with the intent to distribute. There's an additional one in 2007 out of Clayton County for possession of controlled substance, one in 2005 for possession of cocaine, one in 2000 out of Clayton County for possession of controlled substance, additional one in 2000 for possession of a firearm by a convicted felon, and there's another one in 2000 for possession of controlled substance with the intent to distribute. And there are misdemeanor convictions and sentences.
I'm good. That you have given me plenty of information. Thank you.
Yes.
All right. Mr. Glenn.
Yes, Your Honor. Would you like for me to proceed?
I would. It's your turn. I would like to hear from you. I know Mr. Lemons from his many months in drug court. And so I've seen some good, I've seen some struggles. Didn't know he had 49 cycles. I was aware of the Douglas County cargo theft case. I think you were part of that, not meaning you were implicated in it. I think you represented him in that. Yes. So maybe you can put some of this in context. It's not a super happy picture for Mr. Lemons, but maybe he is reaching the age where some of this is behind him.
And I would concur with that, Your Honor. And in that regard, of course, Mr. Davis agreed to the 2 years to serve and making it concurrent with the probation revocation occurred in this particular matter. Your Honor, as you're aware, as you said, he successfully, I believe, completed drug court. And, there was a lot of effort extended in that regard. There was some consideration given, for the fact that there was a lot of hard work involved and assistance with regards to coursework and whatnot. The anti-theft course, as I understand it, would be basically a one-day course. He would also be required to do the 60 hours of community service. And I asked Your Honor initially that the 2 years that he is serving on probation revocation, that it be run concurrently with these current charges, and that he will, of course, with the stay away clause from the railroad properties, etc., he will certainly comply with that. Recitation of facts, I substantially, or Mr. Lemon, more importantly, substantially agrees with. There was some issue or discussion about whether he was, actually there at the site of the yard. And of course, Your Honor, we had a hearing and reviewed evidence. And although there may be some question with regards to the video evidence involved with that, Mr. Lemon's truck was there at the scene, so he accepts responsibility, his responsibility as would be appropriate with regards to this plea. I ask Your Honor that the court accept the negotiated plea terms that have been posed with I guess with the additional request that I would have that there be some incentive with regards to the 5 years of probation that he's in custody now, and he would take care of the 2-year term basically that was involved with the revocation. And after that, Your Honor, with regards to the anti-theft course and 60 hours of community service, Mr. Lemon would certainly be advised by me, and I am comfortable with the fact that he will promptly complete that course in the 60 hours of community service. And upon doing so, Your Honor, I would ask that Mr. Lemon be placed on a non-reporting probation status with the remainder of the 5-year probation term, with the potential or possibility to petition the court for an early termination after a sufficient time that he demonstrated that he has changed his course and has focused his attention on his talents, which revolve around being an excellent mechanic, auto mechanic. He had a business, and I think in that regard, that business, it's my hopes and his hopes that it can be rehabilitated, and that he will get assistance with that, and be able to demonstrate to the court that he's made that transition, and that he's operating his business again successfully. I believe that is everything, and hopefully I was clear with regards to my request to have the appropriate incentives involved here, or taken in consideration by the court, reporting or probation incentives. Mr. Lemons was arrested. He was arrested initially. I think he was on bond, and he was re-arrested. Actually, he was taken to Douglas County, and he served. He was there for a period of time, maybe a month or two, which was an error. They thought that they were going to be able to revoke probation there, but given the fact that these offenses occurred prior to being placed on probation in Douglas County, they discovered that error, and he was released. I think he was there for at least a month or two. And in addition, he was arrested here as he was reporting to probation in Fulton. I believe maybe sometime in April. I'm not real sure, Your Honor, of the date, but it would have predated the this plea and the revocation at least by a couple of months or several months. We can get that all clarified. I mentioned that because I would like to get credit for all the time he was incarcerated for being held for these offenses.
All right, Mr. Glenn, anything else?
No, nothing that I can think of at this moment.
Okay, well, thank you for covering all that. Mr. Lemons, do you have anything you want to add?
Yes, sir. I just wanted to add, I remember, the last time when I had left from up there, when you were, I guess you were talking to the probation lady, and you were like, well, we're going to go on and get all this, behind you, where you won't have no probation or nothing. And, you'll just be dealing with Douglas County, when I come home. So just hoping, that'll be, something that I can just do when I get from prison.
You are hoping when you get out that all you have left is probation? Is that what you're saying?
I was saying, that day when I was up there in front of you and you were like, we need to go on and get that probation and everything behind me. So when I get out from Fulton County, I won't have to deal with nothing but Douglas County probation.
Got it. Okay. Ms. Simpson, how much time is left in the Douglas County case?
That case doesn't expire until February 27th of 2034.
So it would run longer than this case is envisioned to run?
Yes, Judge.
Okay. Got it. And are you able to tell whether he has any special conditions on that, or that's a level of detail that I can't get into?
I can pull up the disposition.
And Your Honor, that may be, I don't know whether it's a matter of record or not, but there are some additional details involved with that.
When you say additional details, meaning in terms of what his sentence is, or in terms of what happened in Douglas County?
With regards to the conditions of his plea, that was a nolo contendere plea entered with the cargo theft case, which explicitly indicated that there was substantial there was some disagreement with regards to the nature or extent of his involvement, and in order to, as we finalize or process the nolo contendere plea, he was actually interviewed, and and that was a condition of accepting the nolo contendere plea, that he interview and be truthful to authority, and he did in fact do that.
Okay.
He is also banished from Douglas County.
Oh, he's banished from Douglas County as part of that sentence.
Yes, he is.
Okay. All right. Well, I appreciate all that information from everyone involved. Mr. Lemons, you and I have worked together for a long time now, in good times and bad. I hope your family is doing all right, and your cars, and I can't remember if you had dogs, plural or one. But you are away from those folks who would like you to be around, because some of your past has caught up with you. I do find there's a factual basis for your plea, and that your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act. Mr. Glenn, do you authorize someone in my office to sign your name electronically to the indictment?
I do, Your Honor. Yes.
Ms. Davis, you?
Yes, Your Honor.
And Mr. Lemons, is it okay if we electronically sign your name to the indictment indicating your plea?
Yes, sir.
All right. Ms. Davis, you had filed a recidivist notice in Mr. Lemons's case. Are you withdrawing that for purposes of the plea?
Yes, Your Honor.
All right. Then that's off the table. Mr. Lemons, I am going to sentence you on each of the 3 counts to 5 years to serve 2 years with a balance on probation. You will need to take an anti-theft course while you're on probation. You'll need to do that in the first 6 months of your probation. You'll need to complete 60 hours of community service. You'll need to do those in the first year of your probation. No contact with your co-defendants, and you'll need to stay away from all railroad yards. That doesn't mean you cannot ride Amtrak if you're a train guy, but it does mean you stay away from a CSX yard or a Norfolk Southern yard, places where trains park and cargo is stored. I suspect it's not a coincidence that you got tangled up in a Douglas County cargo theft situation as well as a Fulton County cargo theft situation. But whatever was going on, I hope for you something different goes on when you get out, so that you can enjoy the second half of your life out and about and not bouncing between local jails. You will get credit for all the time that you've been in connection with these charges. I can't do that math for you, and it's actually, I'm not allowed to. The different custodians of where you were held, Fulton County and elsewhere, will provide that information. But anytime you've been locked up in connection with these charges, you do get credit for all of those days. And I will set a behavioral incentive date of 2 years. So 2 years into your 3 years of probation, if you've taken care of everything you needed to do, the theft course, the community service, and most importantly, you haven't been arrested for anything, not even driving on a suspended license. If there've been no arrests, then probation is free to close out this case early. You still have that Douglas County case that runs a lot longer, but my guess is if you're doing well on probation period, they'll think about shutting out all of them. But that's a probation call and not a judge call. Mr. Glenn, anything else on behalf of your client?
No, Jan, I think that covers everything. And of course, I'll follow up and coordinate the credit for time that he's served in calculating that, the calculations on that.
Okay, and if you get a release date, Mr. Lemons, that doesn't match up, you can always let Mr. Glenn know, and if I need to fix something, I will. Ms. Davis, anything else for the state?
No, Your Honor.
All right, well, Mr. Lemons, good luck with whatever comes next. All right, and thank you to folks from GDC for making him available.
And thank you, Your Honor, and thank you, Ms. Davis.
Thanks, Mr. Glenn.
So I don't see anyone in any booths. What do we have left to do? Who do we need to try to track down? Mr. Smith? Ms. Wood, is that still a plea?
Yes, Judge. I think he's probably just stuck in the breakout room, but
Oh, yeah, let me pull him out of the breakout room. Okay.
But they never took me back to the group chat. No, my line. Oh, here he comes.
There we go. Boom. Ms. Willingham, this is your case?
Yes, Judge.
All right, we'll get you on there. Move spotlight and we'll get Ms. Wood on. Let me get the case up on my screen. 3292. There it is. Okay. Mr. Smith, are you ready to go forward with your plea?
Yes, Your Honor.
You had enough time to speak with Ms. Wood in the breakout room? I think you got stuck in the breakout room, but you had enough time?
Yes, I had enough time to speak with him.
Okay. Then let's get on the record in your case. This is 25 SC 003292. You're represented by Ms. Wood, who is on the call. Ms. Willingham is the prosecutor, also on the call. And in a moment, Ms. Willingham will put you under oath, Mr. Smith, and ask you a bunch of questions about your case and your rights. Before we do that, I need to ask you a couple questions. First, do you waive your right to be here in open court and agree to proceed virtually from the county jail?
Yes, Your Honor.
Second, do you waive your right to have Ms. Wood sitting in that booth with you, but instead having her appear virtually on the same screen with you?
Yes, Your Honor.
All right. You need to let me know if you ever have a question for her that you want to ask in private. I'll get you back in one of those breakout rooms so you guys can have that discussion. Will you do that?
Yes, Your Honor.
Okay. When you are ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Please state your true, correct, and legal name.
James Eddie Smith Jr.
Are you at this time taking or under the influence of any alcohol, medicine, or drugs?
No drugs, no alcohol, but medication.
What do you take medication for?
The wounds in my back, some gabapentin for pain relief.
Okay. Did you get that medicine today?
Yes, I got it this morning.
When you take it, does it make you woozy or drowsy or confused?
No, sir. No, Your
Okay.
Honor.
All right.
How old are you and how far have you gone in school?
I'm 40 years old. Sophomore college.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged with the following offenses on the indictment? Count 1, aggravated assault, family violence with a minimum of 3 years and a maximum of 20, false imprisonment with a minimum of 1 year and a maximum of 10, family violence battery with a minimum of, let me make sure this is the misdemeanor, I'm sorry, with a minimum of 1 day and a maximum of 12 months, and false imprisonment is going to be non pros. Do you understand that?
Yes.
Okay. And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
And have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of these proceedings?
I am.
Have you reviewed the indictment in this case with your client?
I did.
And do you waive formal reading of the indictment?
We do.
And Mr. Smith, have you been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Smith, do you or your attorney know of any outstanding warrants that are related to these charges?
No.
And do you understand you are entering a plea of guilty to the following offenses? Aggravated assault, family violence, and family violence battery?
Yes.
And has your attorney advised you of those minimum and maximums to the charges you are entering a plea to today that we discussed earlier?
Yes.
And do you understand that this is a negotiated plea? I'm sorry, that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 6 months with no violent contact with the victim, complete family violence intervention program, complete 60 hours of community service, maintain and seek gainful employment?
Yes.
And are you aware that the court does not have to accept that recommendation and can sentence you up to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes.
And do you understand that if you do not accept the court sentence, you may withdraw your guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I do.
Do you understand that it is a guilty plea, this is a guilty plea which is permanently recorded on your criminal history?
Yes, I do.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Are you on probation or parole for anything, anywhere?
No.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes,
And do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
yes,
Do you understand that you are not allowed to possess or use a firearm while on probation?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
Do you further understand, because this is a family violence conviction, if you are found in possession of a firearm, you could be charged federally?
yes, I do.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes,
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
yes,
How do you plead to the charges of aggravated assault and family violence battery in indictment 25 SC 003292?
guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes,
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
yes,
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes,
Your Honor, if this case were to proceed to trial, the state would expect to show that on April 18, 2025, officers responded to 2141 Point View Drive, Apartment B in Atlanta, Fulton County. Upon arrival, officers spoke with Tanika Thompson, Tanekia Thompson, Thompson, who stated she was assaulted by her live-in boyfriend, James Smith. Thompson stated that she and Smith were having an argument and Smith would not leave her alone about it. Thompson didn't want to talk anymore, so she was just on the couch looking at her phone. As Smith tried to continue the argument, Thompson left the room and walked to the bedroom. As Thompson laid on the bed, Smith grabbed her by the leg and dragged Thompson off of the bed and back into the living room. Smith then began striking Thompson multiple times about the head and face, causing bruising and lacerations. Thompson tried to exit the apartment through the front door, but Smith grabbed her back by her hair and locked the door, preventing Thompson from leaving. Thompson stated that's when Smith picked up a guitar and struck Thompson about the head, causing some swelling to her head. Thompson stated she was able to retrieve her phone and call 911. Smith fled the scene at the time. Thompson stated she didn't know if Smith would return back to the apartment or not when police arrived, since she was at a neighbor's apartment. Police entered the apartment and located Smith laying on the bed intoxicated. Smith was arrested on scene. Your Honor, I've had an opportunity to speak with Ms. Thompson. It's actually what prompted us asking for this case to be added on. She had previously spoken with ADA Dilligard, who it is my understanding originally there were going to be misdemeanor offers on this case. Ms. Thompson has recanted and stated that she could leave. So she's recanted as to the portion regarding the false imprisonment. She is not recanted as to the other incidents, but she has stated that she could have left the apartment at any time she wanted. Ms. Thompson is the only witness to this case, and without her testifying regarding actually being falsely imprisoned, we recognize that could potentially cause a bit of an issue. But again, she's not negating the other incidents that happened. She was just under the impression that the defendant would be offered misdemeanors. But after a review of his criminal history, I was not willing to do the misdemeanors, as he has a prior conviction out of North Carolina for a sexual battery. I think that's still quasi violent and potentially DV related. I do not know who that victim is. I know that it is not Ms. Thompson, but with that, the state believes this is a fair resolution of this case.
Okay. Did your review of the discovery indicate whether Ms. Thompson had visible injuries at the time law enforcement showed up?
Yes, Your Honor. Which is why the state believes we could move forward as to the ag assault and the battery. It brought into question the false imprisonment.
Got it. Okay. So Ms. Thompson's on the call. Have you talked with her about whether she wants to say anything? She doesn't need to say anything at all, but she's with us.
I did not realize she was on the call, Your Honor. My apologies, Ms. Thompson, for not acknowledging you. I am not sure whether she wanted to speak. I know when her and I spoke, I made it clear to her that I would make sure that I acknowledged exactly what her thoughts were. But if there's anything she would like to add, I would like for her to have that opportunity to do so.
All right, Ms. Thompson, you don't have to say anything at all. You have an absolute right to be here for these proceedings and to say nothing or to say something. But if there is something you want to add, now would be the time to share it with me.
It looks like she's trying to figure out how to.
It does, right? That's why I'm waiting.
Hi, Your Honor. Yes, the ADA, we did speak, and everything she's saying is correct. I was able to leave. I never said he held me against my will. I was able to leave anytime I wanted to. James, he's with me. He's not a violent person. However, this incident right here occurred because of a previous incident where he was in Clayton County Jail and he was attacked. And this particular day, he went to go see a friend down the street, and I'm assuming they were drinking to try to ease the pain, and it spun out of control.
Okay. Well, I'm sorry he's going through some trauma and stress, but that's not justification for you getting beat up. That's not okay.
Well, I'm not saying it is, because it's not. It's definitely not.
So, Ms. Willingham indicated that one of the conditions of probation would be no violent contact, which means Mr. Smith would be able to be around you. That's something you are comfortable with?
It is.
Okay. So if he 4 months from now knocks on your front door and says, "Hey, how you doing?" that's not going to stress you out, make you panic, or be nervous about anything?
No, sir.
Okay. Do you and he have any kids together?
We do not.
Okay. But your relationship at some point was romantic?
Yes, we're actually engaged to be married in April.
Oh, as in April of 26, you are supposed to be married?
Yes.
And that would be the 1-year anniversary of him beating you up. Is the wedding still on track?
You didn't have to bring that part up, but yes.
Okay. Well, then I can see why you would want him around. Okay. I just need to make sure that is good by you, because of course, one of the conditions would be leave Ms. Thompson alone, but it doesn't sound like that's what you're asking for.
No, it's not.
Okay. Well, I appreciate you being here and sharing your perspective. Thank you. All right, Ms. Jackson, criminal history information on Mr. Smith, please.
There are 31 cycles. The last arrest was January the 3rd, excuse me. The last arrest was January the 13th, 2024, out of Taliaferro County, Georgia, for driving while license suspended or revoked. There was no disposition for that arrest. He does appear to have an outstanding hold out of Augusta, Georgia, for a probation violation. The underlying charge was not listed. The date on that warrant was August the 17th, 2023. And there are felony convictions, one in 2024 out of Columbia County, Georgia, for forgery in the 3rd degree, and one in 2012 out of North Carolina for uttering forged instruments and forgery. And there are misdemeanor convictions. There's one in 2020 out of Grovetown, Georgia, for a DUI, and one in 2015 out of North Carolina for a DUI, and one in 2010 out of North Carolina for possession of drug paraphernalia. Nothing in addition, Your Honor.
Thank you. Appreciate it. Ms. Simpson, is your system showing any probation holds?
That case is closed, Judge, as of August of last year.
Okay. All right. So that hold may have expired and shouldn't be keeping you in, Mr. Smith. It sounds like that case is closed out. Ms. Wood.
Thank you, Judge. Mr. Smith has been in custody 138 days. As you heard, he is still with Ms. Thompson. He's planning to return to live with her. He is hopeful he can return to jobs as a barber and also working security. He's 40 years old. He has an associate's degree. He has 9 children, 1 grandchild, and he is eager to put this behind him. So we just ask that you accept the state's recommendation in this case.
All right. Mr. Smith, how old is your oldest child?
20. He's 20 years old.
And how young is your youngest child?
10 years old.
So you had 9 kids within the range of 10 to 20.
Yes.
Okay. Are you done having kids?
Yes.
Okay. That's a fair number. That's a whole baseball team worth of kids. And with the grandkids, you have a pinch runner. And you support all them?
Yes. The best of my ability.
Pardon me?
Best of my ability.
Okay. All right. Good. And the work you do when you are working and not locked up is barber and security?
Yes.
Okay. All right. Anything you want to add?
No, Your Honor.
Okay.
Just ready to get back to work so I can support my family.
Yeah, well, you've got some supporting to do. I find there's a factual basis for your plea. April of this year, something was going on in your head and maybe you had too much to drink or something and you took some of that out on Ms. Thompson. Not okay. Pick on someone your own size who can hit you in the nose on the way back or hit you with a trombone when you hit someone with a guitar. I also find that your plea is knowing and voluntary. That means you've understood what we talked about and no one's forcing you to enter your plea. Do you agree with that?
Yes, Your Honor.
I'm sentencing you pursuant to the Probation Options Management Act. Ms. Willingham, can someone in my office sign the indictment for you?
Yes, Your Honor.
And Ms. Wood?
Yes, Judge.
And Mr. Smith, is it okay if we electronically sign your name indicating your guilty plea?
Yes, Your Honor.
Okay. Your sentence as to count 1 is 5 years to serve 6 months with the balance on probation. Special condition of probation number 1 is to complete a family violence intervention program. You need to understand that that is not one class. It's actually a bunch of classes. So it takes a number of weeks to complete it. You need to enroll in the family violence intervention program within the first 3 months of being released. You'll also need to complete 60, that's 60 hours of community service. You'll need to do those in the first year of your probation. No violent contact with Ms. Thompson. And you will need to submit to a drug and alcohol abuse evaluation. And if that treatment professional, in talking with you about what you drink or smoke or whatever, recommends any treatment, that treatment is part of your probation. So if that person says you need to go to some recovery classes or do a drug screen, that's all part of your probation. And if you don't do it, that would be a violation of your probation. Okay?
Yes, Your Honor.
Ms. Willingham, anything else on behalf of the state?
Nothing from the state, Your Honor.
Okay. Ms. Wood, on behalf of Mr. Smith?
Yeah, thank you.
Okay.
Did you cover counts 2 and 3?
Oh, right. Count 2 is dismissed, and count 3 is 6 months to serve. That will run concurrently with count 1. So the overall sentence is 5 years to serve 6 months, balance probated. I think that's it, other than giving you probation reporting instructions.
So it'll be 48 hours within your release. Just in case we don't know what's going to happen with that old warrant that's still sitting out there. We're aware that it's no longer valid, but just to be on the safe side, we're just going to have you report within 48 hours to the Atlanta Probation Office. So that's going to be 276 Memorial Drive, and that's literally right across the street from where you are. So just make sure you report within 2 days of your release when you get out.
Yeah, it's not right across the street from where you are. You're in the county jail. It's across the street from the city jail, but it's not across the street from Rice Street. 48 hours to get to the Fulton County, the Atlanta Probation Office. Where will you be living when you get out, Mr. Smith?
Sorrento Circle?
Is that in Fulton County?
Yes.
Okay, well then you're going to the right probation office.
We have, Ms. Wood is still waiting on the address. Can Ms. Thompson make sure that she sends the address to Ms. Wood so she can forward it to me?
Will you be staying with Ms. Thompson or staying somewhere else?
Well, Miss Thompson.
All right, Ms. Thompson, can you, she may be gone.
I
Nope,
believe she's gone, Judge. But
Nope, she's still on. Ms. Thompson, can you get your address to Ms. Wood so that she can then get it to, unless you want to just tell probation right now, but we need to get that in the system.
3016 Sorrento Circle. It's SORRENTO, Southwest Atlanta, 30331.
Did you get all that? That was kind of fast.
Yeah, can you repeat the zip code, please?
30331.
Thank you.
All right. Do you need a phone number, a contact phone number?
Ms. Wood provided that part.
Got that. Excellent. Okay. I think we're done. Well, hey, it is September. That means only 7 months before the wedding. I hope you guys start planning.
Oh, it's already planned.
Well, all right. Sounds like someone's in charge in that household. So. All right. See you guys.
Thank you.
Thank you, Judge.
All right. Bye-bye.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you.
Thank you.
Hey, Your Honor.
Yes.
When will I be getting released?
When do you get released?
Yes, from here.
Well, you've done 138 days and you got sentenced to 6 months. So it'll be sometime between now and 42 days from now.
So it's not a 2-for-1?
It may be. The sheriff's going to let you know that.
Okay.
All right.
All right.
See you around.
All right. Thank you.
All right. I think Mr. Carter is our last one. There he is. That's about right. Hey, Mr. Carter, can you hear me?
Yes, sir.
Great. Ms. Wood, you froze up.
She said her internet went out.
It went out. Okay. Whoop, she's on a second time.
Can you hear me, Judge?
You're back.
Okay, sorry about that.
That's okay. Welcome back. You look very serious the whole time. It was frozen in this serious look. All right, we've got Mr. Carter, our add-on, and he is on for a revocation. So let's get on the record for that. It is 22 SC 180392. Mr. Carter, the warrant that I signed in June alleges that you failed to report. And we've already talked about this a little bit, and that you didn't enroll in MRT. But I think Ms. Wood needed to talk with you a little bit. Ms. Wood, what is Mr. Carter wanting to do today?
He will admit, Judge.
Okay, so he's admitting that he failed to report, didn't do the class. You probably sent it, Ms. Simpson, but how much time is left for Mr. Carter?
Actually, I forgot he was added on.
Oh, all right. So you didn't send it. I don't feel bad. I don't have it.
So he has 2 years, 8 months, and 21 days remaining.
All right. And what are you recommending, Ms. Wood, and what happened?
So, Your Honor, he has been in custody since August 20th, so about 15 days. Mr. Carter has informed me, so what happened was, it seems like I don't know, a miscommunication or breakdown in communication between Mr. Carter and his direct probation officer. He was working at the time at Bailey Street Bakery on Northside Drive. The program, I'm still a little unclear about the details of that program. But there was some issue that Mr. Carter had with trying to actually make it there, to make it work with his work hours, Judge. But since then, now he's got a new job waiting for him at Flowers Bakery. He actually told me he starts next week. He's got a good address. The address that he has on file with probation is still his good address. He's got transportation. He seems eager to get back to work, Judge. So he's just hoping for time served and reinstatement, essentially.
And his address is still this address in Conley, Georgia?
Yes, Judge.
How, Mr. Carter, do you get from Conley to Flowers Bakery or a bakery on Northside Drive?
I don't have a car. I've been having my car since I started working at my last job before it closed down.
All right, so you got your own transportation?
Yes, sir.
All right, and this job at Flowers Bakery, you know you have it, or you hope you will get it?
No, I know I have it. I have orientation.
Okay.
September 9th. I had one August the 26th when I was incarcerated. So I got in touch with the H&R lady, and she told me to come in September the 9th.
Okay.
Yeah. My name is Miss Ashley.
Okay. Ms. Simpson, has Mr. Carter had other hiccups on probation, or is this the first one?
This is the first one.
The MRT course, is that the same MRT as what happens in drug court?
I believe so. I don't know if it's like at a separate place.
Well, it would not be at Hope Hall, that I know. I know that is taught elsewhere. It's a common.
I believe actually, if I'm thinking correctly, I think it's actually held over at the DRC.
Okay. It must have been a condition that probation added for some reason. I don't think I would have sentenced someone. I don't remember ever sentencing someone and saying a condition of your probation is you have to do MRT.
Yeah, that probably would have come from one of the evaluations that he had to complete.
Okay. Not because there was a probation violation and it was added.
No,
Okay. It was more as the DCS team is working with him, they concluded, here's a course you need to take.
That's correct.
All right. Mr. Carter, are you opposed to taking the MRT course, or what's the hiccup there?
At that time I was working, and my work schedule changed barely. Sometimes I work in the afternoons, a lot of times I work in the morning. And I kept telling him, like, I wouldn't be able to do that, and my job is, I can't miss no days. We go off punch systems. So I'm a machine operator, so I'm like very needed and very important for me to be there.
Okay, I appreciate your importance, but if probation has said you need to take the MRT course, you're gonna need to take it. So maybe you can find some times that it's offered when you can be there, but having a job is not an excuse to not go to the class that probation tells you you need to go to, okay?
Yes, sir.
So as you get settled in at Flowers Bakery, you should find out from probation, well, when is this class? What are the hours? So that you let your supervisor know, hey, I'm gonna be a great machine operator. I'm gonna make you some good bread or whatever they're making at Flowers, but I'm gonna need to take a break sometimes. I can't be there on Tuesdays for an hour. I'll work late. It's not overtime, whatever it is. But if we are together again, because probation is telling me, hey, Mr. Carter's not doing the MRT course, it'll be a different outcome than maybe what's going to happen here, okay?
Yes, sir.
All right, Ms. Davis, I'm sorry.
Sorry.
That's okay.
He had a palm hearing, and that's where the MRT came from.
Okay. What was the basis for the palm hearing?
He had picked up a misdemeanor harassing phone calls in January. And versus.
Oh, that's on the warrant. It says he must enroll into MRT due to committing harassing phone calls.
They were trying not to do the whole revoke thing.
Got it.
Then they told him to just do the MRT class.
Got it.
For good, and then he didn't do that.
All right, so that's a little more frustrating, Mr. Carter. So you had some issue with this misdemeanor case, and probation did you a solid. Instead of saying, we're writing you up, we're getting a warrant, like, look, do MRT, and then you didn't do MRT. So I don't know that they're gonna cut you a lot of slack next time, but you do need to make sure that you enroll in that course, okay?
I got you.
Well, I know you got me, but you need to actually do it.
I'm gonna do it.
All right, I guess we'll see. Ms. Davis, I'd like your views on this situation.
Yes, Judge. I'm going to be in line with probation's recommendation, which is to basically sentence him to the time that he's already been in custody and to reinstate his probation.
Okay. When did you say orientation was at Flowers Bakery?
September 9th.
September what?
The 9th.
The 9th.
Tuesday.
Yes, it's Tuesday, Monday or Tuesday.
Got it. Okay. Let me check one more thing. Did you complete the family violence intervention program?
Yes, I completed everything that you told me to with this MRT.
Well, MRT is new and different because of this harassing phone call situation, but good job with the family violence intervention program.
Yes.
All right, Mr. Carter, I am going to revoke 18 days, 18 days of your probation as a result of you having these two violations, not reporting, and then when probation gave you a second chance after the misdemeanor to do MRT, you didn't do MRT. I will reinstate your probation and add as a special condition of your probation, if it's not already there, that you enroll within the MRT course by the end of September. That doesn't mean you finish it. It's not a one-day course. It's like Family Violence Intervention Program. You're going to become an expert at the multi-week courses, but you need to have enrolled in it by the end of September. And that is it. Ms. Wood, anything else?
No, Judge, thank you.
Can
Ms.
I ask a
Davis?
No, Your Honor, nothing from the
Okay.
state.
Mr. Carter, yes?
when would I be able to get out of this jail right here?
So you've got 3 more days. 3 more days.
I need to, I respect that, but I need to get out and call her before, this week over to get the time that I need to be there. And I wish I could get out before, like today, to handle my business. To call Miss Ashley and find out what time I need to be there Tuesday.
You don't know. How do you know that you're supposed to be there on Tuesday?
She emailed me, through email and say, be at the orientation September the 9th, but she never gave me the time to be there.
When did she email you?
She did it back in August.
Before you went into custody, or why? Can you get email where you are?
No, it goes to my phone and my sister had my phone. And
Okay, so could your sister email Ashley to find out what time you need to be there on the 9th?
Yeah.
Yeah, why don't you have your sister do that, okay?
All right.
Yeah, you've got a good sister. Tell your sister thank you.
All right.
All right, see you around.
Judge, can I just make sure?
Don't go anywhere yet.
Mr. Carter, make sure when you get out, you need to report back to the Atlanta office within 48 hours of your release.
Okay.
The Atlanta, Conley's not in Fulton County, is it?
It's in Decatur.
We have his case though.
Okay, I'll have him go wherever you tell him to go. I just wasn't, it said Conley and I didn't think that was Fulton. So I don't want him to go to the wrong office and they say, why are you here? We don't know who you are.
Conley can actually be split.
It can?
Yeah, it can be split between Fulton and Clayton.
Where is Conley?
Between, because it's not far from me. So it's near the 285 side.
Oh, so it does bump up against Fulton County. Okay, so you need to go to the Atlanta probation office within 48 hours of your release, okay?
All right.
But what if he gets released on a Friday? He can go on Monday, can't he? Yeah, okay, all right. So make sure you swing by the probation office by early next week at the latest, okay?
That's Memorial Drive, right on Street.
The one on Memorial Drive.
Okay, all right.
Yeah, it's right across the street from the city jail, not the county jail, but the city jail.
Yes, okay.
All right? And they'll be expecting you. Don't disappoint them.
I won't.
All right. Good luck at the new bakery.
All right, thank you, sir.
You bet. See you around.
All right.
You're good to go. All right. I think that covers the calendar. Ms. Davis, did you have anything else?
No, Judge, that's it for me.
Ms. Wood?
No, Judge, thank you.
All right. So tomorrow we're back together. What a week. All right. But just for the morning, afternoon is this endless motion for a new trial. So I will see you guys in the morning. Have a wonderful rest of your day.
Thank you, Judge.
All right. And thank you, Sheriff's team, for getting folks available in the booths.
No problem.
And Ms. Burnett, will we have you all week? Will we have you tomorrow morning?
Yes, sir. You'll have me tomorrow morning. Sorry,
And-
problems. I got all my links.
Excellent. We'll see you then.
Thank you, Judge. Have a good day.
Bye-bye.
Bye.